Today's topic is the concept of police information release and no-win situations. The dangers of a push for the release of information before investigations are completed. The views in this video are my own. Before I get into the heart of this video, I'd like to talk about a concept that's important to keep in mind. It's called a Kafka Trap. It's named after a famous author, and it's a way to make someone or something appear guilty in a logically dishonest way. The basic premise is that if a person or organization denies something or refuses to go along with an accusation, then the fact that they made a denial is used as evidence against them. For example, someone makes a claim that the best sign of being a witch is a person denying that they practice witchcraft. Then a woman is accused of practicing witchcraft. If she denies being a witch, then there's supposed proof that she's a witch. It's crazy, but it's regularly used to condemn others in controversial situations. So keep that concept in mind. The fake premise that to not go along with something is supposedly proof of guilt, because I'll come back to it later on. So now let's talk about police investigations. Police departments do their best to get investigations done quickly, but investigations often contain hundreds of pages of reports, dozens of photographs, multiple interviews, and hours of audio and video recordings. Additionally, although officers do their best on scenes to gather all relevant information, sometimes they need to go back to conduct additional interviews or gather other evidence. Then, literally dozens of reports are generated and reviewed by supervisors. After reports are finalized, they go to the county attorney's office for review to determine if charges are filed. In Maricopa County, during the evidence gathering phase, officers are actually joined by representatives of the county attorney's office. So civilians from an outside entity are supervising the investigation, making sure a fair protocol is followed and ensuring that due process exists for everyone involved. So to summarize, there is tons and tons of evidence gathered, and that evidence is categorized and reviewed in a process that includes outside oversight. And an independent charging decision is then made consistent with the county attorney's sworn duty to uphold the law. Now, there is a recent false narrative that police departments should quickly release all information gathered at critical incident scenes. But this narrative is false for a number of reasons. First, police departments have an obligation to review and redact personal information or information that could impact ongoing criminal investigations before releasing the information to the public. There are times when personal information is disclosed in 911 calls. There are times where people at scenes are naked or exposed. Or there are times where there needs to be follow-up for investigative leads or to identify potential other witnesses. And the ethics rules and the concept of due process require that departments evaluate the information to be released. Because if they don't, if the police release information that could compromise a criminal investigation, the department could face liability or the county attorney may lose the ability to fairly prosecute a case. And at its core, the function of the police department and the critical incident process is to have a full and fair investigation. But now let's get back to the trap. Departments are criticized for either one, releasing incomplete information, or, heaven forbid, releasing inaccurate information regarding ongoing investigations, or two, for conducting thorough investigations and providing accurate information to the public, but not releasing this information quickly enough, whatever quickly enough means. And the Kafka trap is that if the department refuses to release all information immediately, they're somehow guilty of something. This is why the argument to quickly release information makes no sense. First, the desire to be accurate, thorough, and not compromise an ongoing investigation should be the paramount consideration for a police department. Second, if information is released before it's adequately reviewed and before follow-up occurs, mistakes will be made, or the department would be accused, I suppose correctly, of only releasing select information. This is entirely foreseeable because forcing public statements while the investigation is ongoing, based upon an incomplete review of the evidence, will lead to mistakes, and critics will crucify the department for any inaccuracies that would occur. Third, a focus on releasing information before an investigation is over can compromise due process, has the potential to taint jury pools, and could create public condemnation for both civilians and police officers, all before a trial. If a suspect survives a police shooting, that suspect may face criminal charges, and it's fundamentally unfair to release inflammatory information to the public before a charging review occurs. And in all cases, officers involved in critical incidents are facing a review process. In some circumstances, shootings or in custody deaths can result in the officers being charged. And I don't think officers should face a trial in the public while the investigation is ongoing and before the charging review is complete. Inciting public reaction before charging decisions are made for either civilians or officers is wrong. And pushing for early release of an incomplete, potentially inaccurate information is a trap, one that the department and the public should want them to avoid. I'd love to hear your thoughts on this issue. Leave them in the comment section below. I'm Steve Serbalik. Thanks for watching, and stay safe out there. If you'd like even more information as to why police departments don't release information quickly, click on the video up here. And to subscribe for more videos related to law enforcement issues, click the channel icon here. Videos are released every Sunday at 5:30 p.m. Arizona time.